Well, good evening. My name's Graham Smith. I'm from the law firm Bird & Bird, and I'm rather unexpectedly chairing this evening. You were going to have a professional chair, a TV interviewer, I believe, but unfortunately he was unable to make it, and I'm afraid you're now going to be stuck with my rather amateur efforts. I hope you will bear with me. The topic of this evening is the Digital Economy Act changing the habits of a generation. The Digital Economy Act, I think it's fair to say, is one of the most controversial pieces of legislation that went through in the closing hours even of the last administration, both in substance and also in the way that it was, the procedural way that it was dealt with at the end. However, I think the focus of this evening, we hope, is going to be more looking forward than rehashing old battles. So I suspect that will inevitably come up. And to help us with that, we have an extremely distinguished and knowledgeable panel. We have Lord Putnam on our extreme, I was going to say on our extreme right. That's
perfectly capable of moving with the times.
Extremely inappropriate
almost right. I think I'm
description.
Mind the coalition seat.
He's to your left.
Andrew Heaney from the ISP Talk, Richard Mollett from the BPI, and Lord Lucas, who again, with Lord Putnam, was extremely active in the debates in the House of Lords, and indeed with the presence of Lord Putnam and Lord Lucas, I hope we can say that this evening we'll be indulging in a considerable amount of peer-to-peer thought sharing, if not file sharing. Right, that's the bad pun out of the way for the evening. The format is going to be that each of the four speakers will speak for about 10 minutes, and then at the end of each we will have about 5 minutes for questions from the panel, and if we have time from the audience to that speaker, and then at the end of all four we'll have hopefully about 30 to 45 minutes for a general Q&A. And so with that, I'd like to introduce our first speaker, who is going to be Lord Putnam, generally somebody who in the corny phrase needs no introduction, but I think we can all fairly say is a hero of the British film industry, and has many achievements to his name in advertising, film production, long association with education, and in many other areas. I won't go on, but ask Lord Putnam to start us off this evening.
Thanks very much. First of all, I can say with real justification, I like coming to the Frontline Club. My dad was a press photographer, one of two of you may know, and for 6 years of his life was a combat photographer. So I'm particularly proud of him, and I know all of these images extremely well. If I had to sum up the bill, one of the things I learned from it, it would be that phrase, never let the perfect be the enemy of the good. Because I think that a lot of the hot air that was generated during the passage of the bill, certainly through the Lords, were different people attempting to create something perfect, which was never going to be possible. And when I say the enemy of the good, I do mean the enemy of the good, because I actually think that the Digital Britain report, Stephen Carter's original report, was a very, very good piece of work indeed. Quite remarkable. During my 13 years working in and around government, probably the closest thing I think I ever read to a genuinely visionary, far-reaching document that understood the implications of what it was trying to wrestle with. So I'm a big fan of that. I also happen to be convinced in my own mind that Web 3, as and when it arrives, will be in every single respect a paid-for medium. And that's something we're going to have to find a way of moving towards. I think that micropayment will be the name of the game by 2015, being arbitrary. And so therefore, what I'd always hoped was that the Digital Britain bill, this bill, would be a sort of paving bill, moving towards a world where payment would be, in one form or another, would be the norm, and not necessarily argued over. But that brings me immediately to one of the flaws I felt in the government's approach. To me, there was the most remarkable opportunity, one-off opportunity, to once and for all create a settlement between firmer legislation in terms of obtaining payment for legitimate material, and particularly commercial material, as set off against a rather more generous concept of free use. I wanted to see development, really quite radical development of free use concepts, so that the schools, for example, were not burdened with unnecessary and cumbersome copyright restrictions, and that any number of other institutions which were related to learning, real learning, could be freed up. So I was really hoping to see an important trade-off once and for all between government action to secure the revenues for legitimate copyright owners, and at the same time, say, a much more generous regime from the copyright owners to the common good. We, in a sense, I'm afraid, in the end, got neither. Now, on balance, I just made some notes here. The provisions on online copyright infringement ended up in not a bad place, despite the, and they're not here to defend themselves, so I can say this, despite the almost near lunacy of the Lib Dems at the last minute, who came up with an amendment I don't think they understood, and certainly didn't understand it in terms of its implications. And I do feel very strongly that we cannot, you're going to have someone here who will disagree with me, cannot let the ISPs simply shrug off their responsibilities. The analogy I used and will continue to use is that with, it's not perfect, is that with a chemist shop. You want to see yourself as a retailer, that's fine. Chemists are retailers, but chemists have absolute clear responsibilities in terms of what they can and can't sell, and to whom they sell it, and under what circumstances. And to me, eventually we'll move towards a legislative framework, which I think something like that will be the dominant thought that will lie behind it. I welcome the fact that Ofcom had oversight of the copyright provisions. I'm a big fan of Ofcom. I think it's proved itself to be a very effective organisation that operates in the interests of consumers and has done a great deal to improve citizens' interests generally. But the copyright framework as a whole needs to be examined to ensure that it's fit for purpose. I'm going to quote my colleague Lord Lucas, if I may, because I thought he absolutely nailed this quite early on, I think, or maybe at second reading, or early on in committee, when he said, this is his phrase, we're coming up against what will prove to be impossible over the next decade or two. That's to say, maintaining the idea that the copyright owner has control rather than a right to remuneration. I think he's absolutely bang on. And that's the concept that somehow we've got to start getting our heads around and start pursuing. It wasn't only about copyright. As Deputy Chairman of Channel 4, I very, very much welcome the refreshment and revision in Channel 4's remit, which certainly as a board helped us to focus the organisation where we wanted it and to fight off some of those who actually wanted the opposite. They actually wanted to free up Channel 4 to be a different type of organisation. That was good. I've got to get this off my chest. I was very, very disappointed that the orphan works provisions were dropped. I think this was a great mistake. I think there was the opposition to it was slightly opportunistic. A lot of it came from photographers. But the truth is, there is a real issue here. We cannot, in the long run, expect that tens of thousands of moving images and books in this country are being stored at the cost of the public purse, but the public can't access them. And I actually thought the position taken by the British Library and the protections that were put in place, and frankly the protections that people like Rafe and myself could have added to in terms of making sure they were secure protections, were more than enough to compensate those who were concerned about loss of control. This orphan works issue will not go away. We're going to have to address it. It's already being addressed, as you probably know, in the European Parliament, and I frankly prefer that we had that we created a law or a regime in the UK that we could stand behind, rather than having one imposed on us by the Commission. We'll see. I'll finish with this. What are the lessons I learned from the Digital Economy Act? That in the laws, I'm afraid, Pache, particularly Richard, we were somewhat overwhelmed by the activity of lobbyists, from the Open Rights Society on one side to the ISPs, broadcasters, you name it. It is not a good environment in which to work. This was a bill that, in my judgment, badly needed a scrutiny committee. a pre-listed scrutiny committee that could have not just sat and thought long and hard about it, a cross-party committee, but much more important, I want to explain this, if I explain nothing else. The wonderful thing about scrutiny committees in the Lords, or the Commons for that matter, and this would have been a joint parliamentary committee, is you get to take evidence, and that evidence is, to all intents and purposes, on oath, because it's all recorded, and you have to, as it were, live by what you said. Richard may have something to say about this. For a lobbyist to sit down in a bar and tell you the way they feel that the world is or should be is one thing. For the lobbyist then to sit in front of a committee in a committee room and be questioned and know that all their responses are going to be taken down in evidence is something quite different. And it gives you, as a member of the, in our case, the member of the Lords, the opportunity to sort the wheat from the chaff, to begin to look for the flaws in the argument, to be able to compare argument A against argument B. All of that, Rafe, I think, was denied to us. And it made us extremely vulnerable. And in fact, I can think of 3 or 4 occasions, and I think actually I've got to say the Lib Dem Clause 18 amendments were guilty of this, where people came in at the last minute from something they literally heard the day before over lunch and tried to get it into the bill. That is not a good and sensible way to create legislation. And so in that very important respect, we were denied the opportunity to deliver the bill that many of us would have hoped for. Thank you very much.
Thank you very much indeed, Putnam. I wonder if I can use the chairman's prerogative to kick off and explore something that you raised there a bit more, and that is this idea that it's impossible to maintain the idea that copyright owners have control rather than a right to remuneration. And that, it seems to me, goes to the heart of the scheme that is embodied in the Digital Economy Act, in that there is some degree of carrot and a lot of stick. But the carrot that isn't there is any requirement for rights owners to offer a license to end users to legitimise the activity that they are engaging in, i.e. file sharing, as opposed to saying, you know, stop doing that activity, we don't like you doing that, we want you to consume it in the way that we want you to, with the alternative services that we're going to provide. And it seems to me that lack does illustrate this point about control versus remuneration, and that if the rights owners were interested more in remuneration than control, maybe there's a case for them being more creative about saying, right, you know, we are prepared to embrace those activities and provide a way of paying for them, allowing users to pay for them, rather than keeping control of the way in which they consume this by trying to force them into other ways of consuming the content. So, to put it in the form of a question, do you think there was a case for saying that rights owners should have been made to, if they want to participate in this scheme, to offer a license to enable file sharing to continue legitimately, as part of having access to this notification and potentially technical measures scheme?
Yes, I'm not opposed to the idea of a license, but let me answer it another way, just from my own experience, by comparing and contrasting two ways of viewing the world. I exist effectively because I'm the grateful recipient of royalties from, I produced 30 films, I think about 7 or 8 of them produce income stream, which arrives annually. I'm lucky because I think in 5 of the 8 cases, the company collecting revenues on my behalf is Warner Brothers. They're a global organisation. They're well resourced, and they have a very good accounting procedure. And that's the way I chose to work. A colleague of mine, Jeremy Thomas, saw life very differently. He absolutely fought tooth and nail to make sure that he controlled all of his own copyrights, and does. And he actually effectively owns his films and probably is a significantly wealthier person than I am. But the point was this. I did produce 30 movies. One of the reasons I was able to produce 30 movies was the day I finished a film, I got on with the next one. Jeremy spent a huge amount of his life both preserving, protecting and distributing his own films. It's not what I wanted to do. Now that's in one sense it's a life choice. But my advice on all of this is, and I think this is a sine qua non of this argument, is if you are an IP holder, IP controller, make damn sure that your work is being, and I don't really mind the word control, it doesn't matter, that your work is being exploited, for want of a better word, there's a nice neutral word, exploited by someone who knows what they're doing, who does it globally, who's reliable, who's got a bank account that isn't going to vanish overnight on you, and who will remit, and has a record and a history of making remittances on a regular basis in an honest way. That, to me, is actually what we're trying to move towards. That's one of the reasons why BPI works. It's one of the reasons why I think the music industry, and indeed the publishing industry, is not in bad nick. One of the reasons why, in fact, it's one of the reasons why I get a little concerned about the degree of hysteria that sometimes gets promoted in all of this.
Any comments from the panel?
No,
Yes? No?
No.
I've won that one.
Well, let me, in that case, put a supplementary on that, which is that it seems from what you're saying then that a full-blooded right of remuneration, whereby anyone can use the work so long as they pay, isn't necessarily what you're suggesting by endorsing Lord Lucas's comments on right to control versus right of remuneration.
I interpreted Lord Lucas to speak for himself, but I interpreted Lord Lucas's comments as being extremely sane and sensible, because what he was saying was, and I think he was saying the same as I am, which is remove the neurosis from this argument, accept the fact that control is one issue, but is one issue which has any number of ways of kind of exercising itself. But what should not be, arguable is the right to remuneration by the person who owned the original copyright. What he or she does with it and who ends up controlling it is actually not an issue. Warner Brothers, they've been very clear. Warner Brothers control the rights to the Killing Fields and what Chariots of Fire. There's nothing I can do about that, and I'm perfectly comfortable as long as each year I get an accounting that shows me what they've done with it and what my entitlement to revenue is.
Anyone from the audience at this?
Obviously, unauthorised advance copies. Sorry. Dawn Osborne. Obviously, unauthorised advance copies have to be subject to control.
Of course. I mean,
and
like copies of
territorially
movies
and
before
things like that. I
publication.
mean, that's a huge issue.
No, I mean, one's only talking about published works, clearly. All right. Let's move on now to Andrew Heaney from Talk Talk. Andrew is the Executive Director of Strategy and Regulation for Talk Talk. He was heavily involved in the debate over the digital economy bill, and I think it's fair to say was one of the more outspoken contributors to the debate in many ways. And let's hear what Andrew has to say about the future of this piece of legislation.
I mean, the first thing I think I learnt was, by the way, I probably didn't spend enough time in bars in the Lords and the Commons to start to write the legislation as some of my erstwhile opponents did. Good evening. Just want to put lay down a few sort of bits of background. I'm sure Richard will try and paint ISPs as the villain of the piece, although actually he's normally fairly balanced, so I'm sure he'll do a fine job. But sometimes we're sort of pictured by some, not by Richard necessarily, as the devil incarnate. So just to get a couple of things straight. First of all, we support creators and copyright. We're not trying to destroy copyright or remove it. We're not fighting against copyright term extension or anything like that. We also don't condone or encourage illegal file sharing. Contrary to what a lot of music companies, music publishers, and others put out, and indeed some of your colleagues in the Lords put out, is we don't profit from illegal file sharing. We effectively deliver a pipe to our customers, and they do over it what they like. We're happy to take responsibility. I don't know whether the analogy, we spoke of analogy, we had analogy soup downstairs earlier on, as to whether the chemist is actually the right analogy for what our role is. A chemist can control what goes on in their shop. They can move boxes in and out, they can decide what goes on the shelves, and when somebody comes to buy something, they will ask the pharmacist about what would be a good drug for them. We're very different to that. We provide a pipe onto the internet, and basically we don't control what people do on that pipe. And actually there's a number of laws and legislation out there that says we're not allowed to control and filter in a sense of what they do. But we're happy to play a role, we're happy to take some responsibility. But where we draw a line is we want to make sure that if any action is taken against one of our customers, and I'm sure Simon would say the same about his customers at BT, is that any punishment or action that's taken against them is proportionate, it's fair, and it's not discriminatory, and it doesn't harm innocent people. Now, unfortunately for us, that's where the Digital Economy Act falls down, because it doesn't ensure that. And I think you said earlier, let's not throw out the perfect as long as we keep in the not so good. Well, the problem is actually a lot of the stuff that was in there is unacceptable. It's very, very imperfect. And I think it's also notable, and I agree, I worked with Stephen Carter for 3 years. Huge amount of respect for him, and I thought his Digital Britain report was very good. Unfortunately, actually, the Digital Economy Act was very different to what Stephen Carter's Digital Britain report. His report, for instance, didn't have anything on web blocking at all in it. And it also said any measures such as disconnection, or what we'll call technical measures, disconnecting people who have been accused of illegal file sharing, should be left for separate legislation and for another day. Actually, in fact, disconnection found its way into the bill, and web blocking found its way into the bill. So what is it about the bill that we dislike? The first one is that the bill uses a process of using an IP address to identify an infringer. And the problem is, for anybody at home, you will be allocated one IP address to your internet connection. If you're a family, you will have maybe 3, 4, 5, 6 people using that internet connection. And indeed, other people can hack into it from down the road, sitting in their own living room. Authorised or unauthorised, they can get into it. The bill presumes that the subscriber of that connection is responsible for anybody who's using that connection. And therefore, so for instance, my wife could be using the internet connection, but I will be deemed responsible. That's the way the bill works. As the subscriber of the connection, I will be deemed responsible, and I will be punished if illegal file sharing goes on. We don't think that's appropriate to have legislation that basically knowingly would attack and harm innocent people. We think the legislation should be targeted at the infringer. The other thing we want, which is like really rubbing salt into the wound, is so you've got this thing where the evidence can't properly identify the actual infringer. Is they say, well, what you'd normally do when evidence isn't very strong and it is a bit ropey, is you'd normally have a court to have a look at it, and a proper judicial process. Well, no, actually, the Digital Economy Bill threw that out the window as well, because they've created this sort of parallel extrajudicial process, and not allowing people to have a right to go to court. And the important thing about this process is actually you are presumed to be guilty unless you can prove that actually you're innocent of the offence that you're accused of. So on two fundamental levels, we think the Digital Economy Act is highly flawed. So I was asked to sort of be constructive, I think, and think of a way forward. I think there is things there. As I said, we're happy to take some responsibility. The letter writing element of the Digital Economy Act, we're happy to do with a number of provisos. And that's part of an education campaign. We think the measures such as disconnection and web blocking should be taken out. And where do we think? I think somebody was talking about sticks and carrots earlier on. We think there is a stick there. There is court action that can be taken, and we're happy to help rights holders take court action when it's when they've got sufficient evidence, and to allow them to do that. So that's the right stick. We just think there's some more carrots that need to be put into place. Education has got to be done. I think we need to, in a sense, make it, especially when there is going to be content out there for free, and let's face it, you can't really stop it. This is the genie's out of the bottle. Once a track or a film is on the internet, it's very difficult to stop people getting hold of it illegally or illegally. But the answer is here is actually, if we think about it today, for every 7 people, 6 people, knowing that actually you can get content free, actually pay for it. So the vast majority of people pay for it. And if you ask them why they'll pay for it because it's socially unacceptable to them not to pay for it. I think the focus has got to be on that 1 in 7 who does take it for free, is actually trying to persuade them that it's a socially unacceptable thing to do. And I think the other thing is that trying to make sure that we have services out there, so rather than, in a sense, being forced to use illegal services, there are alternatives out there that are attractively priced. So I really have done my best to try and be constructive, but I think at the heart of the Digital Economy Act is 2 fundamental flaws. They presume people are guilty unless they can prove themselves innocent. And it relies on a piece of evidence that's extremely ropey. And I think because of that, actually, I think a lot's got to go right back to the drawing board to be able to move forward constructively. Thank you.
Thank you, Andrew. Shall I kick off again? Slightly play devil's advocate here. I mean, without wishing to assume what perhaps Richard would say, a lot of rights owners might say, that it's simply not realistic for rights owners to be expected to go after thousands, possibly millions of individuals through court process, and that to expect them to do that is not realistic. And further, that if you encourage that sort of behaviour, that sort of approach, then you risk the sort of activities that were commented on all sides, I think, in Parliament, with certain law firms firing off demands for 500 quid, 750 pounds, whatever, to subscribers whose names they'd obtained through through court orders against the ISPs. And there's certainly I think a swell of opinion in Parliament that wasn't a desirable way of proceeding. So, given that background, is it really right to expect rights owners to pursue individuals through the courts?
I'd say I'm not saying that they would have to. I think the problem is justice costs. A court is there to assess whether the evidence, as to why somebody is guilty outweighs the evidence as to why they're innocent. And for each of these cases, and by the way, and also for somebody to assess whether it's proportionate to disconnect them, or proportionate to tell them off, or proportionate to fine them. That's just the nature of justice. And what they're trying to design here is going, well, justice costs quite a lot of money. Let's see if we can find a way around it. I think, do I expect them to do millions of court cases? Probably not. Would be nice for them to do a few, though. I mean, I think the last time they did any court cases, they're saying it's so important to have sticks here. The last time they did any court cases, if I'm right, is about 4 years ago, I think, was any notable level of court cases, apart from the Cowboys ACS law and the like, who I think Richard will say. I don't think
remember your broom broadcast.
Yeah. I'll happily go on public record as saying it. I think most people would agree with me. I think, by the way, what ACS law, wouldn't support it in any sense. I think what ACS law does show is that the process, which actually has a lot of similarities to the process that's inherent in the Digital Economy Act, hits and directs action against innocent people. So I think, I think the ACS law would stop happening. But actually, what's inherent in it is the same problem that we're facing with the Digital Economy Act, that it's based on an IP address. IP address can't identify an infringer.
And another point that might be made is to say, well, focusing on the subscriber, is there anything actually wrong with suggesting that a subscriber becomes culpable if they have had several letters warning them about what's going or said to be going on their network, and that activity is still continuing?
It might be. I just wish that we'd actually had any form of debate about that, because actually there was no debate about that issue. Is it right for a subscriber to be, as you say, culpable for the actions of other people on their connection? It might be, but there's been absolutely no debate throughout the parliamentary process as to whether that's the right thing to do. I think then if you were to debate that, I think you say, actually, can they do something to prevent it? Actually, it's quite difficult to stop things. It's also quite expensive. A lot of people will have old equipment in their home, both old wireless routers and old games console, that don't support the higher levels of encryption that are demanded by the rights holders. And they might have to spend £100, £200 to upgrade it. Should you be culpable when it costs so much to actually do it? At the moment, I haven't seen an argument to suggest that they should be culpable.
Yes.
Oh.
I think we all know who you are, but could you identify yourself?
A lot of people don't know. I'm Simon Milner from BT. I do a similar job to Andrew, although being BT, we have rather more of us do it than just Andrew seems to be a jack of all trades.
And a master of none.
I wouldn't possibly say that. I just to comment on this ACS law issue. So ACS law, for those who don't know, are a law firm who act on behalf of certain rights holders in pursuing people for money using a perfectly legal process called Norwich Pharmacal, where they go along and get people's identity from ISPs. One thing about them, they're not tested in court, okay? They do not take people to court. What they do is threaten to take them to court and then try to get money out of them. We reckon, but we don't know for certain, around a quarter of people pay, and there's a business model that works for ACS law, okay? But the key thing here is they don't do it on the basis of you're a subscriber, you are responsible. They do it on the basis of you are infringing copyright, or you've authorised somebody else to do it. So it's under the current copyright law. So one of the interesting questions going forward is, can they somehow use these new provisions in the Digital Economy Act to say, actually, you're just a subscriber, and therefore you're responsible? So what we've got is a very messy situation for consumers around understanding copyright law and how it and what it means for them. And I think one of the unfortunate consequences of the Digital Economy Act is it's got worse, not better. And therefore, this whole issue about explaining what copyright is and what people's responsibilities are has become that bit harder because of the Act. And I think that's a problem. And it'd be interesting when we get into the Q&A to hear the panel's perspectives on how can we explain this incredibly complicated thing, especially now it's become more complicated because of the Act.
Can I just make one comment?
Yes.
And I'd be interested what Rafe's reaction was. One of the things that shook me during the passage of the bill was that, and we are not short of lawyers in the Lords, was that there was a general consensus among our legal colleagues that what was being done was dreadful. And what shook me was that the amazing lack of ability of the Law Society or any of the regulatory bodies that deal with the law to do anything at all about it. They were like rabbits caught in a header. You quite rightly said, it's sort of legal. It's wrong. I mean, do you remember Rafe actually read out one of the letters? Someone read out the letter itself. And there was kind of shock horror in the chamber. And there's all these lawyers saying, well, of course, someone should stop this. But then it turns out that the regulatory process of the law doesn't allow you to stop it. And so you had two rogue law firms.
It is a wrong thing which is happening, and it should be being regulated by the courts. They should not be allowing Norwich Pharmacal orders on the basis of evidence which is not properly tested and verified.
Yes.
Unfortunately, we as a legislator don't have a bite on the courts to tell them to improve that, but I really think that's where it ought to be dealt with.
But surely one should recognise that because of the Digital Economy Act, something much worse will happen to people. Not that they will be threatened with, if you don't pay this fine, we will take you to court. And then, unfortunately, 3/4 of people think, well, I don't think they will, so I won't pay, but a quarter do. Under the Digital Economy Act, what you have is people saying, will be facing their internet account being disconnected. So not that they get a thing, but being threatened with that. And they've got no real recourse. And you've still got this lack of understanding about what the law entitles you to do and doesn't entitle you to do. So I think, if anything, the Digital Economy Act has compounded the problem, not helped improve it, and that's very unfortunate.
I will come on to that.
Emma, and then I think we need to move on.
Emma Ascroft from Yahoo. Just wanted to comment on Andrew's point about taking legal cases. It is always really important to test the law in an environment where government, parliament is constantly being lobbied for new laws to protect rights. It's really important that the existing laws that have already been passed are tested. And we have the IPR Enforcement Directive from the European Union, which, the record industry is on record as saying has not been tested in the UK. And it's very important that it is. As a rights holder, we as Yahoo have to enforce our rights. Paying for court cases is costly, it's cumbersome, the legal process doesn't always work, but it's still a very important part of protecting the assets that support our business and our share value. And we consider that as one tool in the box, and it's something that we do willingly. We pay for it, and we don't ask third parties to pay for it. I think that's a very important principle, and I think it's very important for government and parliament to endorse that as a principle, that the law should be tested, and there should be test cases, and that is an important deterrent for potential infringers. And just going back to the point about the legal process being slow and cumbersome, I think everybody in business would agree with that. Enforcing IPR rights is difficult in the courts. We could make it easier, and I think we could all agree that legal reform would be a good thing. But let's focus on that. Let's not shift the problem somewhere else and make somebody else pay for it. And that really is the consequence of the Digital Economy Act. There is a balance of rights and responsibilities, and intermediaries do have roles and responsibilities. But let's make sure that we're actually addressing the right problem and not shifting it somewhere else.
Okay, let's move on. Next is Richard Mollett on my left, who's the Director of Public Affairs at the BPI, the voice of the British recorded music industry. Richard was equally active in the debate over the bill and is extremely expert in all the ramifications of this area. And I'll pass over to Richard without further ado.
Thanks, Graham. Am I on? Am I audible? I won't engage in any post-match analysis. I won't be Alan Hansen to Andrew's Alan Shearer, mainly because I think it's not the right time to be retrospective about the Digital Economy Act. We can have a good chat about what happened in the last week and the last month of the parliamentary process. It's water under the bridge and one for the constitutional experts. I'd rather focus on what we as rights holders and in the BPI, together with the Motion Pictures Association, I suppose we found ourselves in the role of being the major protagonists in the sense because we have the capabilities built up over a number of years of bringing copyright infringement reports of the sort described in the Act. So I just want to talk briefly about what we hope will happen over the next 6 months, and then if and when the Act becomes real, a little bit about technical measures and something about non-peer-to-peer measures and Section 17, which has been alluded to already and is obviously one of the more controversial bits of the legislation. Just to put the Act in context, though, why is it that the BPI and the film lobby and indeed all creative industries were so keen to see some legislation? And that's a keenness, by the way, that goes back to the Gowers Review of 2007, where there was a recommendation on the need for legislation in this area. The reason is because we want to reduce infringement online as the bottom line, and we want to drive people to the very many legal services that already exist for music. And contrary to what one often hears in this debate, the music business in particular is doing a great deal and has always done a great deal to help people get music online. Digital album sales increased 56% last year. Licensing from ad-supported services like Spotify went up 247% last year. A phenomenal rate of growth. So let it not be said that the music industry is relying on legislation to do the dirty work because we're not providing services online. Anyone who goes onto iTunes or We7 or Spotify or mFlow or any of these services knows it's not the case. And contrary to what you alluded to then, Graham, by the way, I mean, I don't think it's right that the Digital Economy Act should have set a compulsory license. That would, in any event, as you know, be contrary to international law and isn't the way that I think rights holders should go around dealing with their rights. As Lord Putnam said, control is important to rights holders. So copyright infringement's going on. It is harmful. It is costing recording artists and the companies who invest in them in the order of £200 million a year, a little bit more again on that for film, and it's rising all the time. And we tried voluntary arrangements. We sat down with people like Andrew and like Simon and indeed others a great many times between 2007 and 2010 to try and get to voluntary arrangements, saying to ISPs, look, you have in your contracts with subscribers already provisions that say don't use this service to infringe copyright or we'll terminate it. Why don't you enforce that contract term? And we could all save ourselves and our parliamentarians a heck of a lot of hard work and late nights. Unfortunately, those voluntary arrangements couldn't be got to, and the government, with the Gowers clock ticking, if you like, knowing it had to do something, did, I'm happy to say, first almost James Purnell and then Lord Carter and then Lord Mandelson, ably supported, I'm happy to say, by people like Jeremy Hunt, then the Shadow Secretary of State, realised that actually legislation was needed. And the main reason it was needed was that the litigation that, as has been said, BPI did engage in quite extensively, 156 cases over 2 years, actually has no deterrent effect on infringement. You can take people to court, and those people you take to court may or may not challenge you on the way to being in front of the judge, but it doesn't do anything to the 7.3 million people who are gaily involved in file sharing on a regular basis. And the idea that you can litigate your way out of this problem, as ISPs seem to think is possible, has been tested, I'm afraid, to destruction. And when you do consumer surveys of this and you ask people, okay, if there's a chance of you going to court, will you stop? They say yes, but only if there's a 1 in 10 chance. Now that's 700,000 legal cases a year, which with the best will in the world, our esteemed legal system won't deal with. So we clearly needed another mechanism to try and deter people from infringing. Litigation isn't the way. And the thought amongst rights holders has always been, well, if you write to people and tell them that what they're doing is wrong, a lot of them are going to say, is it? And will stop. A lot of them will say, I didn't know I was doing it, but I'll check my family, and it will stop. A lot of them will say, I didn't know I was doing it, but I'll secure my router, and they'll stop. A lot of them will say, I'm not going to stop, come and get me. So you write to them again, and then that thought process happens again. And all the consumer research, not just in the UK, but around the world, does say that if you notify people of infringement and encourage them onto legal services, and by the way, that's something else they might say in response as well, I'm doing it illegally because I can't get it online, and you show them the 56 services which prove that to be false, then they tend to stop. Not in always enormous numbers, but at least you start bringing the problem down, and you haven't taken anyone to court, and you haven't played with anyone's service in any way, no technical measures. You've simply written letters and said, do you know there's another way? Now that is at the heart of the Digital Economy Act, and when one reads about the chilling effect that this legislation is apparently going to have, when one reads this is the introduction of Nazi-like censorship, as I've seen some of the more outlandish tech blogs suggest, it's just plain daft. The Digital Economy Act is a way of introducing into the ISP subscriber networks notifications. I wish we could have done it voluntarily. It wasn't to be. So we firmly hope, and it's a long road to go, that some months hence of now, it might be 6 at the inside, it might be a bit longer, we can start identifying infringers merely by their IP address. As been said, we'll write to the ISP, they will write to the corresponding customer. Andrew just described that evidence as extremely ropey. He knows full well that every time that very same evidence gathering process has been used in these litigation cases, it's been passed as extremely robust by a number of High Court judges. It was also good enough for TalkTalk and BT and other ISPs to use in a voluntary trial we did of this system in 2008. There's nothing ropey about it. Now, the evidence system that ACS Law use is extremely ropey because they do not go through the same technical checks as our system does. So yes, they use an IP address and they threaten the fact that it could be matched. But what they don't do, which the BPI and the Motion Pictures Association does, is check that the infringing material is actually there on the address that is saying it's got it. You may have read of this case in California where the offending IP address was a printer because somebody had spoofed the system. Well, our detection methods simply could not fall prey to such a spoof. So there's nothing flimsy about our systems. And the other point that I think gets exaggerated in critique is about subscriber appeals. It's absolutely right that if you are accused of copyright infringement, there should come a point at which you could say, well, look, it wasn't me. And nobody on any side of this debate, so far as I know, has ever argued against that. What some people have said is, that should always be in front of a judge. Well, that isn't a requirement under European law, which simply requires there be a due process. That the Act allows Ofcom to set up an administrative body to deal with that, so that one isn't being dealt with by, I heard the phrase earlier, kangaroo court of rights holders, but actually an administrative process operated and run by an independent regulator. So this idea that one will be hauled in front of a biased beak and told that what you're doing is wrong and unlucky, you haven't got any further right of recourse is plain wrong. It's a plain misconception that is either misunderstood or deliberately put about in order to put people off the Act. And then to come to technical measures. The Act provides, as you'll all know, that should after a year or so of the initial obligations, that is of the notice sending, that infringement doesn't seem to be falling, that the Secretary of State can say, well, we clearly need to do something else. But he can only do that if those notifications have been going for a year And if he's satisfied that rights holders have engaged in litigation, that there's an appropriate level of consumer education campaign going on, and that there are new business services out there. And on all those counts, certainly from the BPI perspective, we say, well, absolutely, and bring it on. Of course we'll bring litigation. We've shown in the past we're willing to do that. We don't think it's the most effective deterrent. We think it doesn't do the job. But if it's what's required, I dare say we'll do it. And, hey, it might work, but I'd be surprised. But the important thing about those technical measures is the deterrent effect. Getting a notification that says, at some point or other, you could face restriction in your service if you carry on with infringement is more likely to make you think again than if it's simply letters all the way down. And I don't think ACS law could actually validly make that threat. And clearly, if ACS law are going round, or would go round, as you suggest they might, Simon, under the regime, making out that they could bring that threat, well, then they should be stopped, and the Law Society should intervene, or whomever. But it's not a valid criticism of the Act to say that some people may misuse its provisions any more than any piece of legislation can be misused by the nefarious. And finally, briefly, I guess, onto Section 17. Now, this is the bit of the Act that deals with non-peer-to-peer provisions, non-peer-to-peer infringement, so people who are downloading from illegal sites. This was a thread of policy that was in every government consultation on the issues since 2008, where there was always, the government were always minded to have some quite complicated provisions for P2P, but were in initial drafts at least, going to give Ofcom a general responsibility to monitor the level of copyright infringement on the internet, which had always been taken to mean by rights holders, I don't know if the ISPs had picked up on it, certainly by rights holders, that Ofcom would be looking at non-P2P. Then when the bill finally emerged, or the draft bill, there was no sight of these provisions, which was why there was this rather unseemly rush towards the end of the legislation to put back in what government had always said would be there, but in the end managed not to be able to draft, due to legal concerns that the department had. Now, that's why we got to those rather perhaps unseemly toings and froings on the Lib Dem benches. It's not my place to comment. But what we've ended up with, beyond that, but what we've ended up with in the Act is a very robust provision that allows the Secretary of State to make an amendment to the copyright law, provided that he is satisfied that there is harm going on, that it is prejudicing rights holders, that the blocking injunction will not cut across national security concerns, and then the judge, the High Court itself, has to be satisfied that legitimate users of the service won't be disadvantaged. In other words, he's not going to look kindly at a blocking injunction against a YouTube or Google or any of these other nightmare scenarios that have been put out there, again, in order to throw people off the trail, which is really, let's bring an action against the Pirate Bay. And just to close, why hasn't 97A been tested? Well, the reason why the current provisions haven't been tested is because they are weak and indeterminate. And the test of a law isn't always whether, when you take it to the court, it works for you. One test is, if it's not even good enough for rights holders to think it's worth taking to the court, then that in itself goes some way to telling you that the law isn't strong enough. And the whole purpose of Section 17 and any provision that flows from it is that it would give a very well-defined injunction against websites that were hosting illegal material where there was clear harm to rights holders. So I think it's a much stronger provision than currently exists. So that's where I hope it'll all go. I dare say we'll be proved wrong, but that's the hope.
Thank you very much indeed, Richard. Continuing my tradition of a question to each of our speakers, I'm going to very unfairly quote a talk I was at last week by Shira Perlmutter from IFPI, who is the, for those of you who don't know, I guess we can call them the international version of the BPI. So yeah, fair description. Talking about these sorts of issues, and she emphasised the importance of winning the hearts and minds of the users. I'm afraid I'm of a generation that associates that phrase with napalming villages in North Vietnam, but put on that on one side, do you think the emphasis, the repeated emphasis on deterrence that you see in these provisions is the right way to win the hearts and minds of the users?
No. But if the Digital Economy Act was all that we were talking about, that would be a problem. But of course, it isn't. And Shira and I, we are absolutely of one mind on this, that the way you deal with copyright infringement anywhere, especially online, is through a combination of three things. You need the enforcement measures, which have to come through legislation, new legislation if that's what's required. You need the new business services, so people have got somewhere to go to legitimately, and you need the education about the value of copyright, such as the Music Matters programme, which the BPI launched recently, where there are branded websites of legal legitimate content together with a whole other sort of viral campaign. So yeah, hearts and minds are important. Of course you don't win hearts and minds through legislation, but legislation isn't there to do that. Legislation is there to help us enforce the law so we can do the other bits.
Any questions from the audience for Richard? I do have another one, but I'm going to save it for the Q&A, I think.